But we're back from the break, and I wanted you to start thinking about arguing for and against, because we're going to break out here, and I'm just going to think, you know, I know that we're, based on the facts that I've given so far, I would say, how many of you all think that Pat is in a lot of trouble? I think the majority. How many of you all think that as a lawyer you would be proud to represent Pat? It depends. Good answer. Okay? And sometimes we don't get to choose our patients as nurses. We don't get to choose our patients as APRNs, right? But we do the very best for them. The reason I'm so proud of all of us in this room and the million nurses plus is because no matter color, religion, whatever, sexual orientation, we take care of patients. Okay, we may not always agree with their lifestyle, we may not always agree with their choices, we may not always agree with how they treat them, but we treat them with respect and dignity. You know, some of the greatest nurses I have respect for are the Israeli nurses and vice versa that take care of Palestinians. They just blew up and killed some children and they're in an ICU. And I read one on Sigma Theta Tau, proud member of the last 20 years, and I read a study how they dealt with that. And they said we take care of them just like any other patient, even though they killed some of our own people, you know? So, I mean, it's a tough job we have. And so when lawyers complain and whine about their clients, I go, you try being a nurse and being spat on, yelled at, hit, and we don't have a gun to protect ourselves on a Saturday night in an ER, you know? So I'm just saying that we have a tough job, so don't feel so sorry for lawyers, right? I don't think very many people do, but I want you all to feel a little bit bad because it's a very hard thing. And we're going to practice law, pretend, today, and we're going to split the room up here in a minute. Let's do an exercise in the real practice of law. We've gone through all the morning with the civil and criminal examples. We've had excellent questions on the break about insurance. We'll get into that a little bit and how it works. We've had excellent questions on, which is a whole day, on contracting and collaboration agreements. But we're going to focus a little bit on the civil and criminal aspects. And for those of you who can't make the afternoon session, I'll have the PowerPoint available. I'll give Mr. Rollins the PowerPoint, and we're going to do a little videotape that I'll load up and, you know, highlights of things to help people out. And we need a judge, a jury, and attorneys. Who in here has done management before? Probably everybody, you know. We need a good judge, you know. It's in your blood, Miss Smith. We might want to make you a judge. Yes, why me, right? Right? And I'll say, I think we need somebody who keeps an open mind, and not that we all can. And you don't even have to get up from your seat or wear a black robe or anything. You can just, you know, and we'll just pretend, and we can switch roles, and then we'll ask, what would you do as a prosecutor? What would you do as defense? So I'm not trying to pick on anybody, but jury and attorneys, and we'll just make everybody kind of interchange roles. Take the pressure off, because it's a hard case. Okay, let's start with picking a jury. Okay, as you see in the second bullet point, voir dire. That's an old French Norman term that says tell the truth. And when we pick a jury, how many of y'all have done jury duty? About half or more raised your hands. How many of y'all have been a foreman on a jury? Probably not many nurses, because again, that fear that I told you from both sides, whether it's a criminal case prosecutor or defense attorney, they see that nurses are authority figures. We may not always feel like we're authority figures or powerful in our jobs, but people say these people have positions of authority. That's why policemen too, they try to strike policemen off. State courts vary widely on the manner to pick the jury. Sometimes the judge says, you have 10 minutes to pick the jury. On a capital murder case, we may take weeks to pick the jury. I've had a panel as big as 200. Federal court's different. The judge, not the lawyers, ask most of the questions. Then we do follow-up questions. Okay? So federal court's different. The judge selects the jury and the attorneys are frequently given the opportunity, but the judge really limits us. Federal court, the judge can stop you and ask questions himself of the witness. The judge can exclude testimony. In federal court, the judge is all powerful. Either way, and in state court, I like to think of it, the judge is more like an umpire, calls a ball, a strike a strike. Either way, strikes for certain reasons for cause, that means eliminating people from a jury, can be made for no reason at all, as long as it's not a reason because a man or a woman or black or Hispanic or white or women, etc. If it's for a legitimate or for no reason at all, but as long as you're not doing it because, you know, I met a lawyer down in the valley. This is kind of, you know, off color, but the word gringo for us down there is kind of like Anglo-Saxon, you know, wasp, right? So one guy, I told him, well, how are you going to pick this jury, Homero? And Homero, he's on the Laredo, and he said, eeny, meeny, miny, mo, all the gringos have to go. I said, Homero, man, I mean, you know, you get sanctioned for that, you know. He goes, well, they're going to hang my guy. He's undocumented, you know. And I said, how do you know? And when we picked the jury, we found out. I said, I'll watch this. And I told him, how many of you and there were people from the country. And I said, how many of you tired of the undocumented aliens walking through your land? Most of the Hispanics had land too. Guess what? You can't always assume. They said they come in there, they mess up stuff, they've ransacked my house, I've worked hard for this ranch, and they come in there, and they were more against it, and they had skin like mine, right? And they said they were more against it. I had, and I said, you see, and that kind of prejudice works both ways, you know. That's why. So when we pick a jury, we already found out that a lot of people are missing work. A lot of people are paying $10 for parking and getting paid $8 a day. So they're -2 in the hole, and they're praying that it's not and they don't know what kind of case it is when they come in. They can't tell you we don't know if it's OJ or it's a traffic ticket, you know? So anyway, let's start out. Here's the judge back here. And he says, counsel, you ready? All right, bring in the jury. Bailiff brings in a panel of about these many, maybe 60 people. And let's say I'm the prosecutor. I'm here, and defense is here. I'll stay kind of confined here because Dave's got the camera on me. But I'll pretend that, let's start out with a criminal trial first. I'm the prosecutor, and let's say this is federal court, and the judge has already asked some preliminary questions. How many of you all have law enforcement in your background, cousins, brothers, sisters? They ask the general questions. How many of you all, and this is the way the judge hammers us at the knees, he says, how many of you all are already leaning one way or another without hearing the case? Can you all be fair? Well, who's going to say they're not fair? No one. Everybody's going to say they're fair. Okay? But that's when our talent is asking certain specific questions. So let's just say the federal, where I'm reined in a lot more, I'll say, thank you, Judge, I appreciate it. Always be nice to the judge. Why? Because the jury hates a lawyer who's disrespectful to the judge. Okay, and I'm the prosecutor, and I also know that people have a lot of respect for nurses, and they'll probably give her a bigger benefit of the doubt than a drug dealer. So I'm not going to be mean to the nurse either when I put her on the stand, if she takes the stand. But I'm going to pick the jury, and I'll say, I'll go row by row generally. Okay, row 1, row 2, row 3, and I'll say, good morning, how are y'all doing? My name's Joe Flores. I'm a nurse practitioner, and I'm also a registered nurse. And the kind of difference between those is that I can prescribe drugs, and I can do physicals, do a lot of the things doctors can do. But in Texas, I have to collaborate with a doctor, you know, make sure I'm doing things right, and he oversees some percentage of my charts and things like that. But I love the law too. So what am I doing? Establishing rapport, like I've talked about before. And then I'll just say, first row, how many of y'all are in healthcare? Well, of course, all y'all raise your hand and stuff. And then I'm making notes. I have a chart, 1 through 60. They've given me a packet that shows your address, you're married. They tell me your religious, denomination sometimes. It has a different, your occupation, how much school you've had, whether you've ever been in trouble with the law. So I know a little bit about each of you. But you have a card, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. And why do you have cards? Because especially in federal, if you're working on a drug kingpin case, they don't want the drug cartel to know your name. So we're going to call you by juror number 42, juror number 41. If you sit on a jury, they still keep it like that, especially in these cases with life and death. Okay? So we're asking questions like that. How many of you all have somebody in your family in row number 1 that has served as a law enforcement official? Anybody? Nobody? How about row number 2? Do you have somebody in your family that is a policeman? Anybody? Cousins, brothers, sisters? Oh, juror number 12. No, please. I mean, shout it out. What does he do as a fireman? Is he a volunteer fireman, or does he? What? He's a volunteer fireman in a small town. And does he work closely with law enforcement, answer calls, things like that? Would that in any way affect you sitting on a jury and hearing the case? In fact, you would be able to sit here, hear all the evidence, and wait and render a decision? Would you be able to follow the judge's instructions to not let bias, prejudice, or sympathy affect you? All right. Well, thank you. As a prosecutor, those are the kind of questions. So if my guy's saying, no way, she looks like she's going to hammer my nurse, right? I'm going to say, okay, let me see if I can get her back. You know, I'm taking notes and everything. I'll come back to you and ask questions, you know. So we do the same thing, the same kind of questions. And we say, how many of y'all have ever had anybody in your family or that you know, I don't want to get too personal, but just raise your hand, that have ever OD'd on drugs? Row number 1. How many of y'all dealt with people, treated them, that have had an overdose? We're getting there, okay. And then you'd say juror number 7. And juror number 7, what were the circumstances? You don't have to tell me their name, but did they die? No. What sort of drug did they have a problem with, or that?
She was on prescription medicines. She's an older lady. I don't know why she did it. She didn't make everything she said.
Now, that being said, would that affect your opinion or sitting on the case and say, Joe, I just don't feel comfortable sitting on a case about addiction? You'd be able to listen to all the evidence and the judge's instructions. Okay. Okay. You think so. See, the other guy's scribbling. Yeah. Okay. You think so. Okay. And then you say, how many of y'all, and I don't want to get too personal, so you don't want to embarrass anybody, but you'd say, how many of y'all have had to put up with somebody who drinks alcohol? The whole panel. How many have had to put up with drunks? You know? In practice or personal, how many of y'all have had to put up with alcoholic drunks? Almost everybody, right? Juror number 2, how did you feel having to put up with somebody who is intoxicated?
Hurt is somebody in my family, so it's sad.
And addiction impacts your family, and in what kind of way? How did it impact the family?
Just through missing work, not providing financially, things like that.
I saw some other hands raised. Who else has had problems like that, maybe personally with their family? And we don't want to pry too much. See, I don't want to put anybody on the spot. Anybody? Yes, ma'am, in the blue.
Yes.
Well, blue and green, it's pretty. But do you agree with juror number 2 that says that it impacted the family, having to miss work, cover for people, maybe even have to say a little white lie about why they didn't go to work? Has that ever happened?
Yes.
And how did that make you feel?
Sad.
And this case is about addiction, but about somebody that may have been prescribing drugs, but you see it, you've had to deal with addiction firsthand. Can you sit on this jury and be fair? And you know, that's just a loaded question. Who's going to say they're not fair, right? But I would ask and say, could you sit here and hear all the evidence?
Yes.
Okay. And if given the responsibility of having to decide whether this person needs to go to jail or not, would you be able to go ahead and sentence that person to jail if found guilty? If I gave you the right evidence and beyond a reasonable doubt, could you give them jail time?
Yes.
Thank you. Oh man, you know, I mean, it's just right, perfect juror for me. For the other guy, maybe not so much, right? So then we go to the defense side and say, I'm following up on what the prosecutor said. I have been defending people for a very long time. My name's Joe Smith, and say, you know, I just want to, you know, ask how many of you all would give more weight and credibility to a person that has a badge and a gun to a regular citizen? How many of y'all in the front row think that if a policeman says it's true versus a regular citizen, that you would give a little bit more validity? Be honest. That's what it's voir dire for. Tell the truth. Let's be honest. How many of y'all would think that if a policeman says something, it carries a little bit more weight than the accused? I appreciate your honesty. I really don't, but I'm like, right. But I say, well, thank you for your no, I really do. Thank you for your honesty. And juror number 6, you said that, and you said it a little reluctantly, but why? Why would you give somebody that is a policeman a little bit more than somebody that's accused of, say, prescribing drugs illegally?
It depends on each individual situation, but by and large, they're sworn to uphold the law.
And the ordinary citizen may not have the same burden of doing that. Okay. Juror number 7, I saw you shaking your head. What do you think about what juror number 6 just said? Do you agree with her or disagree?
Well, the one time I sat on a jury, I did that. I thought that the policeman was more valid to testify than the other person. We can't, it's a bias that we really believe in the system.
Well, and I appreciate that. Juror number 7 has just said, you know, that believes in the system, that the policemen, you know, are sworn to uphold that system, that it's kind of almost natural for you to give the policeman a little bit more of a benefit of the doubt than a citizen accused, correct? Okay, so I'm writing down this, and then I'd say now in the second row, who agrees with juror number 7 about that, giving policemen a little bit more of a benefit of the doubt than somebody who's been accused? Anybody in the second row? Let me put it the other way for the third row. Right? Let me put it another way in the third row. How many of y'all think that policemen lie? Be honest. Okay? You see how the dynamic of that question changed?
They just did all that stuff and told us not to do all that stuff. Walk by there with a pizza and say you're they lie all the time.
Right? But then you get people talking in the jury, like, quiet, order, you know, yeah. Oh, sorry, judge. Counsel, get up here. And he's going, the judge will go, you trying to bust this panel? This is how I try to bust a panel. I'll say, how many of y'all are already one way or the other? You've heard kind of what the case is about. How many of y'all are leaning just a little bit towards the government and the police? Be honest. How many of y'all are leaning just a little bit in the front row? Y'all already starting out giving a little head start to the police. How many of y'all? Be honest. Anybody that just, you might give them a little bit of a head start. The scales of justice are just tipped slightly policemen, because I heard juror number 6 and 7. Is it already starting out a little bit more? Because you're giving a little bit more credibility to the policeman. I'm not trying to pick on y'all. I'm just asking. Could, you know, it's a hard question, but are you giving it a little bit more tilt? And I'll get back to y'all. In other words, I'm trying to get them to commit, you know, a little bit, but it's hard. But let's get back to the question. We've heard a lot about policemen, and I saw a number of you raise your hand saying that you think policemen sometimes aren't always forthcoming. All right? Can you raise your hand one more time so I can get your numbers down? Juror number 12, 13, 16, 19, 20. Now the court reporter's writing all this down, okay? I'm writing down in my little squares, juror number 1, 2. I'm writing, because this is going, you got to mark, and you got to use a little check, and never put an X. I never put an X on 6 and 7, because what if you stay on the jury? I had a jury, the first trial I ever did, and she goes, I saw you X out my name. And I'm still here. I was like, oh no. Yeah, rookie mistake. That's worse than the fly being open, you know. Yeah, so I always put a check. Thank you for your honesty, you know. And I'm always weary of somebody who said, how many of y'all really want to be on this jury? And if I see somebody's hand stand up and just eager eyes, I don't want them on my jury. They got too much time on their hands, you know. So you get a little flavor of the jury selection. Then what happens is we go back in a room. I would go back in my room with my client. The DA may have his helpers, and I bring my legal team with me and say, okay, we go back in there. I said, what about 6 and 7? We're defending the nurse. What about 6 and 7 over there? Do you think we should keep them?
No,
Why?
because it's not based on the evidence base. You're supposed no bias and blind and just listen to the evidence.
But they said they could listen to the evidence. If we go object to them in front of
But
the
if
judge
they
and they
think
stay on
you-
the jury, they're going to take it out on
Maybe
us.
they will take sides. That's not fair.
They didn't say that. See, the
But
judge
they
heard them say they
implied
said
that.
they could be fair.
No,
Here
they
we are going back and
implied
forth.
that.
Right.
Because they didn't respect.
But that's not
the
enough.
fact.
That's not. If we strike them, we
You
better.
need to respect the fact, no matter the fact, what it is,
You
who
have to
say
give a
that.
reason why you're rejecting every juror?
That's what the peremptory strikes are for. We get 6 burns no matter what. We can burn them just to burn them, but we're burning our strikes. We only have a few silver bullets, and then the rest we have to challenge for cause. So I would save my strikes. I would bring them up. Now, you all go take a break, and then when we come back, I'm not a break here. I'm saying in our pattern. We're going to take a break in a minute. We're about to do, but so we would go out. Y'all take coffee downstairs. Go, whatever. You're not supposed to talk about the case. The judge says don't talk about the case between each other. Don't text. No Facebook. People are Facebooking all the time. I'm in court and I hate that lawyer. I had one guy have to tell him. One friend of mine who was a very handsome-looking man. One of the jurors Facebooked him and said, is there anything possibility after the trial? And so he had to go disclose to the judge, and the judge was like, "What did I say?" And you contacted one of the, he goes, "I'm not going to say what you said but he showed me the message. We're not going to get it on the record, but you've wasted all our time because then you bust the jury panel up." That's why we get alternates. We have like 12 people, we get 2 extras. Somebody's going to get sick, somebody's going to get a sick child. We need to have 2 alternates, and we always usually agree. So you've heard the kind of dialogue between Ms. Ho and I, my co-counsel, and I'm like, if we're going to strike somebody for cause, they better sound like, they're real biased. Some people are already starting out. Now, we may bring them back, and after the break, what they'll do is, outside of everybody's presence, the judge will go, and the judge runs for election in state courts. So he's going to be a nice guy. You guys vote for him or her. So he'll say, we're going to call you all individually. Some of the lawyers may have some questions for you guys. We would bring you back in, and then you're under oath. All jurors have to take the oath. They're going to tell the truth. So the judge would ask, now you said something about that, and the lawyers are here. They're going to ask you a few more questions. And I would ask more of the same kind of questions, and then I'd say, after you leave, I'd say, Judge, I think she was already leaning one way or the other. I agree with my co-counsel, Ms. Ho, and I think under, blah, blah versus blah, blah, that she's already committed herself in the Cortez versus whatever state. That case says that if you're already committed a little bit of one way, she said that she'd give a little bit more credibility to the police officer. I think, and then sometimes the judge, depending on the judge, will say, I agree, I'm going to go ahead and dismiss her. She'll be excused. And we get our cause granted, okay? Or if we don't want to mess with all that, we can just burn them with a peremptory strike, but we're losing our silver bullets. Because say we have a panel of 100, we only can get rid of 6, as long as it's not because they're white, Asian, Hispanic, or black or something, and we had a good reason, but we burned the strike. The challenges for cause are difficult. You have to show that they have a bias. And you just heard the judge say, how many of y'all can be fair? Well, so we know where we're going. That's what I was saying. You heard the judge say, they all said they could be fair. Because why does the judge want to do that? He doesn't want to bust a panel. If we lose a bunch of people, then we have to bring in a bunch of people down from the jury panel. We have to start the whole process for a day or 2 or a week again to pick the jury. And what? In between all these breaks, the judges are bringing in other cases, hearing divorces, hearing child protective cases. They're busy. In between a trial, the justice system does not stop. Every time there's a break, the judge doesn't get a break. He's calling in other cases. He's doing a plea. He's doing all these other things. So anyway, so that's jury selection. So once the jury's selected, we do an opening statement. The opening statement, once we impanel a jury, after we've done our strikes and everything, I'm going to try to deselect who I don't want. They're going to deselect who they don't want. And somehow or another, we're going to make a jury. And then the jury takes their oath. They sit in, they're impaneled. And then we get to tell them, like Paul Harvey used to say, the rest of the story. Once the jury's selected, opening statements. And on a criminal case, we would say, you know, ladies and gentlemen of the jury, my name is Joe Flores, and I am proud to represent the state. I represent the people. We have a person right here. Now I can tell you what this case is about. This case is about a pill mill. This is about a person that wrote prescriptions. You're going to hear evidence from the doctor. You're going to hear evidence from an elderly doctor who's going to say that behind his back, she wrote all these scripts and these narcos, and she was just trying to make a profit. It was her clinic. She was just pulling the strings with him, making a bunch of money. You're going to hear evidence that she went ahead and made these scripts. No matter if the person was 5 feet tall, 8 feet tall, no matter if they weighed 400 pounds or 100 pounds, she was given the same scripts over and over and over again. You're going to hear that she cared more about profit than patients. At the end of this trial, you're going to hear evidence that's going to have, within the shadow of a doubt, within reasonable doubt, and that's the doubt that is most certain that you have in the most personal affairs of your life, that if that you hear this evidence, you will come back with a guilty plea. Usually we talk a lot more than that, but you know, he's going to say the evidence will show, the evidence will show, the evidence will show, you know, burden of proof. We talk about the burden of proof, reasonable doubt. Then the defense lawyer comes up there, and you got a hard row to hoe, right? You have to say, well, you heard the prosecutor up there, and he's right about one thing. They have the burden of proof. We don't have to prove anything. They have the burden. It's like getting down the football field. They got to get there not 50 yards down the field like in a car wreck, not 30 yards down the field for a field goal. They got to get right there on the hash mark. They have to prove their case. And the evidence is going to show that she had individualized care plans for every patient. The evidence is going to show that she told DPS and DEA that there was a problem and she was a victim of prescription fraud. The evidence is further going to show that not only did she have individualized plans, but she had a doctor that was there, and you're going to see that the doctor is just trying to save his own skin. At the end of the day, they're not going to be able to prove their case. And I'm going to promise you one thing. There's going to be reasonable doubt throughout this whole trial. And when you render a verdict of not guilty, you're going to feel good about it, because it's a jury of their peers. You're going to hear all the evidence, and you're going to hear a lot of evidence that's going to go against his case that he simply can't prove. Thank you. You know, so now everybody's like, well, that sounded good. That other one sounded good. And so you kind of equal it out. So we've done our opening statement. If a plea of guilty is reached, a nurse, now at any time, people will ask me, even after this, can we reach a deal? At all times we can reach a deal. I'm like, I'm offering her 10 years probation, not a day in jail, but she gives up her ticket. No jail time. She gives up her ticket. I've got her. We got 7,000 counts. She's facing 2 to 10 in the pen. Or this, the offer stands, but once we start after opening, I call my first witness, the deal's off the table. The DAs have a lot of discretion. If this is a U.S. attorney case, it's even worse because there's mandatory minimums on certain kinds of drug cases. They will have to do time. On a federal case, 96% conviction rates. Because you have the might of the government behind you that has all this access, and whatever anybody says, when you have a nice young handsome DEA agent with a gun, the badge and everything, and they're swooning to look at him, you know, they're going to believe in him, you know. I mean, he's saying, you know, she's guilty and this is what we found and we did all this detective work. It's hard not to. The federal is different from the state. The state has less assets. The state has a lot less. When the government, federal government, they've been working this case years. You know, they've been watching her years. So it's a different standard. I've worked both. So it's so we have to think about those things. That they offer a plea, usually with federal, it still involves jail time. I had a case and someone asked me a very good question. What if they just gave up their DEA and their nursing license? Sometimes that's part of a deal. If they punch their ticket and they get out of nursing entirely, sometimes they'll say, we're going to go ahead and pass on the prosecution. And sometimes I'll say, your money or your life, what do you want? And so that's where we're at. Trial risks, as I said, vast majority of cases are pled out, 90% or more. Trial is fraught with uncertainty. You never know what 12 people in a jury are going to decide. Our jury system is great, but not perfect. We are human. No matter how many times we say we're not biased, prejudiced, we are all full of prejudice. Little old ladies walking down an alley, and I'm dressed I'll be right there. And I'm dressed in a biker outfit, and I've got a goatee, and I'm wearing mirror sunglasses, and I'm walking towards a 6 foot, 250 pounder, and I'm walking towards a little frail old lady, and another little old lady was in the same situation. She sees a big Latino walking towards her in like a biker thing. Is she going to be more afraid of me at midnight or the little old lady with a walker? That's called bias and prejudice. We all have prejudices. So, if I see somebody driving a Cadillac that weighs 90 pounds with osteoporosis doing this on 610, I'm going to be prejudiced and I'm going to give her a lot of room on 610 South and North. And I'm going to say, Miss Jones needs lots of room to drive. I love her. She's going to Bel Air. Let her go to Bel Air. Let her go back to the city homes. Our jury system is great, but not perfect. One jury can decide to convict, another can decide to acquit. We've seen that. Anything can and does happen at trial. You never know the twisted turns. And you never know if you're going to go to trial or not because of the backlog. And after opening statements in a criminal civil case, the side that has the burden of proof must call their witnesses. The other side gets to cross-examine. Cross-examination is wide open. A good little skill in cross-examination is it doesn't matter what the answer is. I never ask a who, what, where, or why question in cross-examination because I don't care. If you're the DEA agent and I'm the defense agent, I'm going to ask questions that are pretty confrontational but nice. I'm not going to be like in court slamming down my hand. The judge won't tolerate it. But I'll go, did you investigate everything? You looked at all the documents. Now, you swore an oath to uphold the law. Do you believe in fairness? Now, this fairness means that you'll look at all the documents, right? I'd like to go to Exhibit 30, and I have somebody like Dave, and then we go pap up here on the screen. It's all about showmanship, and I'll say, did you look at that document? And let's say you didn't. You'd say, no. Well, let's go to Exhibit 31. You didn't look at that document, didn't you? In other words, you just looked at 10 cases out of 7,000. You think that's fair to my client? 3% of the cases you looked at, you think that's fair? It doesn't matter what you say. I'm trying to make you look biased. And then, I give a little sidelong look to the jury. No more questions from this witness, And a good law professor will say, when you strike oil, stop drilling. I made my point. Stop beating up. Nobody likes for anybody to beat up a nurse or a policeman or a teacher. So I already made my point and just say, would it have been a good idea if the district attorney had showed you all these documents? I'll pass the witness. And I made my point. And then they come back and try to fix you and clean you up. And say, but I showed you all these others. And based on these, on just this, we're not just smoke, there's fire. They actually made prescriptions that were just the same for all those 10, correct? And let me show you. Let's go to Exhibit 34. Government Exhibit 34, that's an 82-year-old lady, right? Correct? You looked at that one. And then that 82-year-old lady that weighs 40 kilos, she gave her the same 5 times a day narco, 2 tablets, and to this 250-pound Hispanic man. Same amount, right? Isn't that correct? And then you'd say, yes, because I've prepped you. Yeah, you're my star witness. And I'd say, how many of these cases have you investigated? You'd say, 500 or whatever. And I'd say, how long have you been a DEA agent?
20 years.
And, in all that time, you're very thorough on what you investigate, correct? But it's almost impossible to look at every page of 70,000 prescriptions or even 7,000 prescriptions, correct? But because of the public health issues, when you see trouble, you've got to investigate it, correct?
Yes.
And you've got a job to do, right? Pass the witness. You see? And then we go back and forth, and the jury's like, oh, it's like a tennis match, okay? So redirect, go back. Once you make a point, move on. The judge doesn't like it to be repetitive, and you do not want to get chewed out by a judge. So juries act unpredictably. They can be swayed by many factors. Venue and your judge are also factors. Sometimes the judges are ornery, and they don't understand that. Juries think that judges have a lot of authority, and they're the guys that control their courtroom. So you're trying to advocate for your client. At the same time, you've got to do a very delicate dance of being respectful to the court, even if the court's not so respectful to you. Politics, 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 especially in the state. The judges run every 4 years for the most part, except Court of Appeals every 6 in Texas. In the federal system, the judge is appointed for life. So they don't have to worry about putting up campaign signs. That's why they have so much power.
Wow.
Yeah, they're there for life. They get chosen by Congress. They get appointed and the senator gives them the nod, and it's break time now. And we'll be back with Pat's Problems, lunchtime, civil litigation. Yes.
You know how when they say in a jury of your peers?
Well, no, it's not. Oh, sorry, it's not lunchtime yet. I thought I saw 12. My eyes are. Yeah, we got plenty of time.
A jury of your peers. And when you're a professional being investigated, or if you're up for trial, and your peers are other lay people, like how is that balanced, equal, and fair?
Well, we all are citizens of this country. We come from different backgrounds, and we're getting a hodgepodge. I may luck out and get 2 nurse practitioners, but you may not want 2 nurse practitioners on your jury, because we tend to be a little bit harder on ourselves.
I don't think they're using the term peer as professional peers. It's just
It's citizenry.
Right?
Citizenry. In other words, I can have a panel of a street sweeper and a banker. I can have a panel. I've had guys that own their own business, and I've had people that are policemen on. I've had insurance adjusters that stayed on a panel because they didn't tell the whole truth. They said, you didn't ask if I had been an insurance adjuster in the past. You just asked, so they play a little fast and loose. We had juror misconduct one time on a federal case where I didn't know. I had been a campaign manager on a campaign. It was a dirty campaign. Dave and I did boy, we had a good commercial too against the lady. I won't mention her name, but she's still on YouTube. But they had it in for me, and I wasn't even the candidate, but I ran the campaign. They knew I created the commercial. And so the niece was on a juror. Well, the niece talks about the case to that old the old campaign, the person who ran, the political opponent. They went and talked about the case. They violated their duty. Don't talk about the case to anybody. So after they convicted my guy, she went and told my law partner, yeah, I heard you guys got your butt kicked. My niece told me everything. Well, we filed juror misconduct, asked for a new trial. They had to come in. The federal marshals went and picked them up and brought them in. We had a full-blown hearing, and the judge said, even if I find your conduct reprehensible, she said, I told you not to talk about it, but it doesn't rise to the level of juror misconduct. I'm going to deny the motion for a new trial. But that kind of thing. You see, so that's why it's important that you don't talk about the case. You never know. Afterward, we know that jurors have written books, and stuff, but you don't talk about it during the case. So just very quickly, APRNs are increasingly being given more responsibility, therefore facing more exposure. Right now, the medical, Loretta Lynch, and if you don't know who she is, look her up. She's like the biggest lawyer, attorney general, okay? And she has, the power on they put their focus on what? Healthcare fraud and prescriptions right now. It's a big epidemic as they see it, and they're looking at that, and they're also looking at policemen overreaching their power and all these people getting killed. So those are like the top 3 that we're looking at right now. And the days of not carrying your own malpractice insurance are over. We know that. And then we go on a civil lawsuit. We've got some time. Pre-suit notice. Sometimes you get a letter before you get sued that says, I'm going to sue you. Under Medical Liability Improvement Act, Chapter 74 of the code in Texas, Texas Practice Civil Remedies Code, It says, before I sue you, I got to tell you I'm going to sue you. And I got to tell you why I'm going to sue you. And I'm going to have to send it to you certified. And I'm going to have to send all this stuff. And then I'm going to do the same to the doctor, to the hospital, to the clinic. To every provider that I'm going to sue, I have to give you notice. And I have to do it in a really certain way. What happened was in 2003, the legislature passed Proposition 4, House Bill 4, and that became Chapter 74, where for the good for us, it limits how much we can get. But it was an unfair limit on victims, which is if you have a nursing home person that was abused, allegedly neglected, it wasn't turned, craters, stage 4s or unstageables, all this stuff, they don't make money. So they can only collect up to $250,000, up to 3 providers aggregate $750,000. If the same person that was a banker that makes $120,000 a year got the same thing happen to them and they lost wages, well, then we get to say the guy's 50, he could have worked for 25 more years, 25 times 120 plus the $250,000 cap. So that's the difference. A sweet little old lady who gets the same bad malpractice can only get $250,000 maybe $750 max, and this person can get $10 million. That's why the Liability Act is a little bit unfair, because of economic damages. You can't sue on pain and suffering more than $250,000 per provider. So when we were looking at a medical malpractice example, that's what we're looking at. Here in our example, and you can just Google Chapter 74. You can read all about all that. Chapter 74, Medical Liability Improvement Act. We don't have to worry as much because lawsuits have dropped by more than half in Texas. And plus, think about it. Even if lawyers knew about how much and how smart we were, they're still thinking that we're chasing bedpans and wear like red cross on our head with a white cap, and you know. They don't know all of our practice, but even if they did, think about that approval rating with the public. How many people want to sue a nurse or a nurse practitioner and beat up on them? It's not very, most often they sue the clinic, they sue the doctor, and then they bring in and threaten to sue the nurse, and they never do. I know because I've represented both sides, even after tort reform. They don't want to, no jury likes somebody to beat up on a teacher, policeman, or a nurse, you know, because those are kind of the bedrock, you know, of our society. So pre-suit notice, then the lawsuit, like we saw in our example, that lawsuit's on wrongful death, on giving prescription drugs and getting hooked. We've gone through a trial, jury selection on the criminal, same with the civil. We do the same sort of arguments, but what's happened with the burden of proof? I used the football example, getting it down right there by the end zone. You got like a little bit to go. On a civil case in Texas, here's the scales of justice. You just got to tip it 51%, just like in a car wreck. All you got to prove is about more likely than not, by the preponderance of the evidence, that they did something wrong. That's the different burden. There's a clear and convincing evidence. It's about 75%, like on child cases involving children. And then the reasonable doubt is the highest burden, putting somebody in jail. But on a civil case, all you have to do is tip the scales of justice a little bit. More likely than not, they did it. So, and then on trial, here's the deal. You can appeal. You can appeal on criminal or civil. Most appeals are denied. Some appeals get denied in part, and sometimes they send them back. I've tried cases 3 times. Had to go back and do it another time because they found a pellet error or they found this or that. And sometimes we've had lawsuits. I've got guys still appealing a federal sentence that are 10 years old, you know, and then they fire me, nothing personal, and then because I told them there's nothing to appeal. Ethically, I can't appeal. Oh, you're a bad lawyer. I'm not gonna. I say no, you're a bad client because you want to appeal, and you're guilty of sin. But what they do is they'll do their own appeals in handwriting and keep appealing, and they'll even file the Supreme Court and all that and make a bunch of paper, and most of the time the appeals are denied. So the pre-suit notice, if you're sued, you receive notice by service, certified. Notify your insurance carrier. If you don't notify your insurance carrier pretty quick, usually within 30 days, 60 days, they can deny that they have to cover you because you didn't give us enough notice. You also need to know what your insurance covers, and you need the insurance for the report to the BON and need to notify them. If you get a complaint and you carry your own insurance, you let your insurance know. If you get a complaint, knock on wood, everybody knock on wood from the board. And then role of the nurse malpractice, the duty to defend is the difference between indemnify. The insurance has the duty to indemnify. It requires the insurance company to retain a lawyer to defend you. But that doesn't mean that they have to pay a settlement. If you find that your actions were outside the scope of insurance, intentional acts, if a person molested a child, their insurance is probably not going to pay for it. That's an intentional act. There's exclusions to insurance policies you have to read, just like on your windstorm, on this too. You have to read and you have to ask questions and, you know, have a lawyer look at it that you know, or that, you know, ask your own insurance company. You'll be on hold for a while, but you'll get the answers. That's the deal. Should our APRN have insurance? Why? You have your own attorney. Most policies cover the cost of depositions. They pay for your attorney. Most policies cover like $25,000 for the board. That's more than enough money to go in front of the board, go to Austin for a few hearings, and even if we have to go to State Office of Administrative Hearing. The institution's insurance policy pays the lawyer, not the nurse. In other words, if your doctor or your clinic is carrying your policy, there's mixed loyalties there. It's important that whether it's a criminal or civil, or now especially with EMR, you can't go back and open a note. You know, if you do that, the chart has to remain pretty much intact. You don't want to look like you tampered with the chart in any way, because right there, that smoke, there's fire, obviously. Discussions about the lawsuit. The APRN would be advised by a lawyer not to discuss the case, whether it's civil, the civil case, because just like in a criminal, anybody can become a witness against you. MAs, doctors. In our example, the doctor ratted on her, and the MA, everybody ran for cover and said she did it. So the APRN is perceived threat to practice, and the collaborating and agent MD is in damage control mode and listening to his attorney. You can be sure he's got a lawyer. And the ex-employee medical assistant is seen as a loose cannon. Maybe he can afford an attorney, or maybe he can't, but maybe he cut a deal and said, I don't need an attorney, I'll just say what they want me to say. The battle of paper shuffling in a civil case, once the lawsuit starts, they start sending information back and forth. People are like, why are they asking me where I went to high school? Why are they asking me how many times I've been married? Why are they asking me if I've committed bankruptcy? Because all that's up for grabs. Anything reasonably calculated to lead to the truth in a matter, they can ask you. When they ask for a deposition, they can ask if you ever got picked up for stealing bubble gum at 18 years old in college. They can run all your data, and they can ask you all that stuff if it's reasonably calculated to lead to something discoverable, which says pretty much everything. APRN might cut a deal with the plaintiff attorney, but remember that any such deal would be confidential, separate and distinct from a probable board case. The DA may be able to get information on such a settlement. In other words, if you have a lawyer that doesn't know criminal law, okay, and he takes you to the board, and say you were accused by the board of endangering the elderly, and you go and you answer all these questions in front of the board, and they take down that record, the BON can take that down and take it to a DA, and the DA can prosecute you for endangering the elderly, which is a felony. Anything you say to the board is open game for a DA to prosecute, and more, the DA is prosecuting on cases and using that stuff. Yes, ma'am. Juror number 2.
I'm just curious, like, how can personal information help them? Like, when they ask, oh, you're married and like stole something in high school. Like,
It goes to credibility. If you lie about things, if you steal, I want the jury to know about it. I want the jury to make, if I'm the lawyer against you, I want to make you look bad. And I want to use that. You lied on your, nursing application about being a thief of bubble gum in 1999. You should have told them, right? And you lied to the board. And that says to the jury, you lie to the board, you lie to us. And it goes to bias, prejudice.
What about those nurses who are married the third time?
Huh?
What about those people who've been married 3 times? They automatically.
Well, I'd like to go talk to their ex-spouses and find out how crazy they are. You know, it's my right, you know, yeah. And request for disclosure, do you have insurance? Request for production, give me all your driver's license, your certifications, everything. Interrogatories, they're asked questions about your personal background. Request for admission, admit or deny you gave all this medication. Yes, ma'am.
For civil lawsuits, can they go after your personal assets?
Yes. If you have insurance and the judgment exceeds it, generally they'll just go after the policy. Sometimes it's punitive damages and everything. They can try to go above and beyond the policy, but it's rare because usually insurance is all you're going to get. But some lawyers that are very aggressive will go after judgments and go after everything you have.
What if you're a PLLC?
I'm sorry?
What if you're a PLLC?
Well, now that's a question for about another 8-hour session, but the quick answer is that it will help prevent and limit your liability up to the amount of stuff that you have in there. But if you're commingling funds, if say you were paying the rent out of the cabin and using PLLC money, I can what's called pierce that corporate veil and I can destroy that LLC. If I find one thing that you commingled funds with your person, went to Vegas and it was totally not related, right, there you go. There you go, smart lady. Depositions are just like statements out of court. I can videotape them and I can play them to a jury. And you're sworn just like you're under, say a doctor's not available, say that doctor, I want to get his deposition, and then he passed away, poor guy. The 78-year-old anesthesiologist, I got his statement and everything, I can use it in court. Battle of the experts, I'd probably, if we have enough money, and a lot of the time nurses don't, but the board gets, or the DA, or the opposite side in a civil case, they've got their experts saying bad, bad, bad. And you remember the media and politics have a major role in the process. They say not to watch TV, they say not to read the internet. When a jury sits on there, it's hard to not turn off that TV, or you start hearing, you walk out of the room, the good person tries to, but it still impacts them, you know, by virtue of the expert's training, experience, and knowledge. But a lot of the time I try to discredit the expert by saying, you're a hired gun for the board. You'll say anything. How many times have you ever testified for a nurse? None. And I'll say, how many times have you testified for the board? 78. So you make a living off of testifying for the board, right? You know, you're biased. Okay? So pretrial modes of disposition. Typically a lawsuit is resolved before trial. Motion for summary judgment says, I'm going to try to get the whole case dismissed, saying they don't have anything, not even a little bit of evidence. They filed this frivolously. They can file a motion for summary judgment saying we've proved every element. Judge, we don't need to go to trial. She's guilty of sin. Motion to dismiss, we can move to dismiss for lack of evidence. Non-suited, and I can refile it within a certain time. I don't see the APRN or the pain clinic sliding out of this one without being on a civil case unscathed. Maybe on the criminal, I can get her a pass. The board's going to have something to say about that this afternoon. Mediation, same thing. You go in there, you say one side, the other side says the other side. Sometimes it's binding arbitration, sometimes it's not. It depends. Mediation is voluntary unless you have like a binding mediation clause. If y'all have any questions on mediation, I can answer those at the break. But basically, it's a chance to try to reach an agreement before you go to trial. Because again, you never know what 12 people on a jury are going to think. Remember, going to trial is risky. The trial of a lawsuit is extremely demanding. When I go to trial, I'm sleeping 3 hours a night if I'm lucky, and it's 18-hour days. You're talking to witnesses, you're reviewing documents, you're preparing everything, and emotionally on the person that's on trial, it's physically, psychologically, emotionally exhausting having to be in there and having your life torn apart. The trial phase of the litigation may take several years, taking depositions, doing all this, and then continuances because the judge is listening to a child molestation case, the judge is listening to a capital murder case, and you're the last thing on his mind. Nonetheless, when the trial on a given date is possible but uncertain, you still got to be ready. You got to hurry up and get ready and wait. That's what they say. Both the nurse and the lawyer must be adequately prepared. Appellate remedies, if one side wins, you can appeal. You can settle things post-judgment on a civil case. You know, we can do high-lows. They say, We used to do high lows when we'd say on a nursing home case back in the day when they pay a bunch of money, I'd say, okay, if I lose, you still got to pay me 100. If the jury gives me 5 million, all you got to do is pay me $1 million. Deal? And we can do those. And everybody sign off on them. It's called a high low. So the jury doesn't know about the high low. The jury gives a $10 million verdict and go, we showed them, but we did a deal, and it's totally legal, where we can do a high low, 100,000, 1 million. So no matter if I get a gazillion dollars, all I get the max is, 5 million. If I lose, I still get 100,000. So that's kind of things that you can do. And no one knows what 12 people in a jury will do. Twists and turns. No matter how ironclad a case you think you have, a smart lawyer can water down your case. How many people have come in and said, this is a slam dunk? I go, nothing's a slam dunk. It's just like surgery. Even a haircut's dangerous. Break time. Be thinking about how this, y'all coming back, be thinking about how this is going to be evaluated by the BON.